this presentation on Discrimination 101, the basics. Please note, information provided in this presentation may contain legal information. Legal information is not the same as legal advice, which is the application of law to an individual's specific circumstances. The Human Rights Bureau will do its best to provide neutral information that is accurate and useful, but we recommend you consult a lawyer if you want professional assurance that the information and your interpretation of it is appropriate to your particular situation. In order to understand what discrimination is, we must first define it. Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. In order to understand the definition of discrimination, we must break down and define some of its terms. This slide shows a list of the protected areas under anti-discrimination laws that the Bureau enforces. The protected areas include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. As you can see, the Bureau received the most cases for filing in the area of employment for fiscal year 2020. Trailing far behind at 7% were cases filed in the area of governmental services. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Now let's walk through these protected classes to give you a clearer understanding. First up is age. Under federal law, someone belongs to the protected class of age if they are 40 years old or older. In Montana, an individual belongs to this protected class at any age. Age does not mean level of maturity or ability to handle responsibility. Discrimination complaints based on the protected class of sex can assert that an individual was treated less favorably because of their biological sex or because they do not conform with the stereotypes of their sex. There are a variety of subcategories under sex as well, including pregnancy, sexual orientation, and gender identity. A lot of our sex-based complaints filed at the Bureau allege sexual harassment, which can include harassment from people of the same sex as the charging party. Title VII of the Civil Rights Act, the federal law that prohibits race discrimination, does not contain a definition of race. Race discrimination includes discrimination on the basis of ancestry or physical or cultural characteristics associated with a certain race, such as skin color, hair texture or styles, or certain facial features. For coding purposes and reporting, race includes white or Caucasian, Black or African American, Native Hawaiian or Pacific Islander, American Indian or Alaska Native, bi or multiracial, and Asian. The protected class of color not only refers to white and black comparisons, but also extends to discrimination based on shades of skin color. For example, there have been cases where an African American with a darker skin color has felt harassed by other African Americans who are lighter skinned simply because of their darker skin color. Most of us have a general understanding of religion. A Christian, Muslim, Jew, or Mormon, just to name a few, can fall under the protected class of religion. However, this protected class also includes the absence of religion, meaning that a person can file because he or she was not the preferred religion. Also, in the area of employment, a person can ask for religious accommodations, such as time off to attend a powwow or to observe their religion's Sabbath. Creed is similar to religion. It is a deeply held belief, but according to the legislative history of the Montana Human Rights Act, it is broader. Things that fit within the protected class of creed include vegetarianism, white supremacy, or the belief that one should not be vaccinated. Disability is very broadly defined as a physical or mental impairment that substantially limits a major life activity. If someone characterizes or perceives another to be a person with a disability, or that person has a record of a disability, the person would fall under this protected class as well. National origin is defined as ancestry according to the Montana Code. Some examples include Arab, Afghani or Middle Easterner, East Indian, Hispanic, and Mexican. The protected class of marital status protects people from discrimination based on their marital status and who they are married to. An example includes a couple that worked together and once they got married were told that one of them had to leave. Another example is a school district who discharged a bus driver because her husband was convicted of running a meth operation. Both of these cases were marital status cases. In the area of governmental services and employment, the government cannot discriminate against someone based on their publicly held, publicly shared belief. Political belief or ideas is much broader than just your party affiliations. It includes your stance on issues of public concern that you hold out to the public. As an example, the Bureau had a case in which an individual felt she was passed over for a position in local government because she stated she had attended city council meetings and publicly advocated for government transparency. Her public vocalization in support of government transparency placed her in the protected class of political belief. But as mentioned, this protected class only applies to government employment, governmental services, licensing and public contracts, things that are underneath government authority. The protected class of familial status applies only in housing cases. The Montana Code annotated defines it as having a child or children who live or will live with a person. For example, a landlord cannot rent to only people with children above the age of 5. Retaliation has been for some time and continues to be the second highest filing the Bureau receives each year. Retaliation is statutorily defined and is different than the dictionary definition of the word. A lot of people are confused by this, and the Bureau fields a couple of calls each week where someone complains about retaliation, but what they really experienced doesn't fall under the statutes we enforce. The Merriam-Webster definition of retaliate or retaliation is to return like for like or get revenge. However, the definition under the state and federal anti-discrimination laws is much more specific regarding the reason or motivation behind the revenge taken. The Bureau only has the authority to investigate complaints of retaliation that allege that a respondent took a significant adverse act against a charging party because that person engaged in protected activity. When considering whether or not an employer's action is a significant adverse act, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. So to understand the legal definition of retaliation analyzed by the Bureau, you must also understand what protected activity is. Protected activity includes opposition, participation, and requests for accommodation. We'll now look a little closer at each of these protected activities. Opposition can be protected even if it's informal. A person does not have to use magic words like harassment or discrimination. At the Bureau, we look at it from the perspective of whether a charging party said something to the respondent that put the respondent on notice that the charging party was concerned about something that would fall within the Bureau's purview. Said another way, is the charging party voicing a concern that the Bureau might be interested in? However, opposition must be carried out reasonably and in good faith. If the manner of opposition is unreasonable, the charging party will likely give the respondent a legitimate non-retaliatory reason to take an adverse action against them. For example, an employee who yells at his boss in front of coworkers a list of complaints that also includes an allegation of racism will likely face consequences for insubordination. The unreasonable manner with which the employee reacted will give his boss a legitimate, non-retaliatory reason to discipline him. Also, the protection for opposition is limited to those who act with a reasonable good faith belief that the conduct opposed is unlawful or could become unlawful if repeated. For example, what if a woman complains to her boss that she does not like that her coworker asked her out on a date? Well, this one act may not legally qualify as sexual harassment, but the coworker could possibly continue on a path that would become harassing if left unchecked. Therefore, the woman's complaint of an incident that could manifest as sexual harassment would be protected activity. The Bureau recognizes that a charging party may not prevail on a complaint if it was brought in bad faith or if the manner of opposition was not reasonable. So we have covered opposition as a protected activity, and we'll now go over participation as a protected activity. Respondents cannot punish a person for filing a complaint, serving as a witness, or participating in any other way in an investigation matter, even if the underlying discrimination allegation is unsuccessful or untimely. This has been interpreted to include participation in an employer's internal complaint process, even if a charge of discrimination has not yet been filed. The third and last type of protected activity we need to discuss is requests for accommodation. Requesting an accommodation for either a disability or religion is a protected activity as well. An example of a request for religious accommodation can be a Native American employee asking for time off to attend a powwow. A request for an accommodation for disability, in its simplest terms, is when a charging party requests a modification or change due to a mental or physical health condition. An example of this in the area of employment is an employee requesting time off to seek out cancer treatments. An example of this in the area of public accommodation is a shopper asking a store for a modification to the COVID-19 mask policy because of a disability. This concludes our presentation on discrimination basics. If you'd like to learn more about the Montana Human Rights Bureau or discrimination laws in Montana, please visit our website at www.montanadiscrimination.com or call us toll-free at 1-800-542-0807 or locally at 406-444-2884.